Okay, thank you. I understand we have a special request on this item tonight. Brody, would you introduce yourself and give us a quick rundown on this?
Yeah, thanks, Mr. Paul. My name is Brody Conover. I'm an attorney with Ricker, Gray & Wyatt. And we serve special counsel to the city of Urbana on various matters, including before the BZA tonight. I did want to let you know, I believe you're aware, Mr. Paul, that the applicant, Thor Equities, through their attorneys, Vory's, Sayer and Seymour, this afternoon or this morning, submitted a motion to continue the hearing until the May 11th. Joe Miller, who represents Thor at Vory's, I'm going to give him an opportunity to get his motion, so let him explain it, and then let the board decide how they'd like to proceed.
Thank you, Mr. Conover. Thank you, Chairman Paul, members of the board. I'm Joe Miller of the Vory's law firm on behalf of applicants, appellants, Thor Equities LLC, Urbana Owner 1 LLC, and Highland 55 Investments LLC. I may refer to them as the applicant or as Thor. I'm joined this evening by my colleagues, Chris Ingram and Brody Voigt. We did file this morning, and if you need a copy of it, we can certainly get it to you, a motion for continuance of this hearing just until your next regularly scheduled meeting on May 11th, a modest request in light of the grave due process concerns that we have. Let me explain. The city code requires that notice be mailed 10 days prior to a hearing, prior to tonight's hearing. Thor and Vory's, the applicant and its attorneys, never received any notice, never received any notice at all of this hearing. And in fact, we only learned of it when Friday afternoon I sent a letter to the city saying this needs to be set for a hearing. I then heard from Mr. Conover that it was set for this evening. We would not have even been here otherwise, and we have not had adequate time to prepare for this hearing. I do understand that this is a matter of public interest and import, but I've got to stress to you that it is also a matter of private property rights. This is a quasi-judicial hearing that determines those private property rights, and the due process needs to be afforded by the city to the applicant, to Thor. And I submit to you that without the required notice being received by the applicant, we simply have not been able to prepare. I've not even seen that staff report until just now. Add into the fact, and I know you know this, there's only 4 members present. That also presents a very serious due process concern. And so we're asking for a modest continuance to your next regularly scheduled meeting that could help alleviate those very concerns and allow this to proceed in a fair and fulsome manner. Thank you.
Thank you. Anything to add?
I'm
This
happy
is
to-
unusual for us.
Sure.
This is not normal process for us. So guide us on, like, if we overstep or say something wrong, let us know.
Sure.
We want to make sure we get it right.
Yeah, sure. So my expectation, I'm happy to answer any questions that the board has. My expectation is that you guys have dealt with tabling a hearing before continuing it to the next meeting. It's not an uncommon request. As it relates to some of the items that Mr. Miller raised, certainly able to answer any questions that the board may have about whether notice was sent out. I know the zoning department's here and can help answer those as well. So if the board has questions about the request, happy to answer them.
I do agree with Mr. Conover. This is a common request. You may face it from time to time, but I would say with the grave due process concerns that we have for a full and fair hearing for the applicant, that this modest continuance is the only appropriate thing to do. We'll come back May 11th and be fully prepared, but when we receive no notice until late Friday afternoon that this was even happening, you have to afford the appellant their due process rights.
Okay. For questions? I'm sure we'll have some.
I would restrict those just to the board, right? Yes.
Yes,
Any questions
yes.
from the board?
Lisa, would you like to go first?
So how did this get overlooked?
So the letting, are you providing notice? Is that what you mean?
Correct.
Yeah, so the city statutes, codified ordinances require that the city provide 2 types of notice, at least 10 days prior to any hearing before the BZA. One, it must be a legal ad essentially in the newspaper. That was done at least 10 days prior. It also requires that the parties of interest, and so that's the property owner and any property owners within 200 feet, first class mail be sent at least 10 days prior. And both of those notice requirements in the codified ordinances were satisfied. It ran in the newspaper at least 10 days prior, and the first class mail was issued or sent at least 10 days prior to the hearing.
To date, my client continues to check, and they have not received the notice. I would also add that my law firm filed the notice of appeal with our email addresses, with our telephone numbers, and we received no notice, which again would be very common in any other city. And so, like I say, I'm making a modest request. We'll come prepared on May 11th to be heard fully and fairly, but I submit that that's the only appropriate thing to do this evening.
Thank you.
Vince?
You're not prepared, why? You've
Because
known this whole issue has been here for a long time, and I can't understand how you can't be prepared.
this matter is of great significance, and I understand it's of significance to people in this room tonight. It's of huge significance to my client, multi-million-dollar, approaching billion-dollar investment in this city. And to make us come in here with 2.5 days notice and try to pull together everything in response to a staff report we haven't seen with only 4 voting members, I submit to you is unfair and contrary to your own city's code. I urge you to grant this modest continuance. We will be severely prejudiced otherwise.
We can go back around if you
Yeah,
want.
that's all right now.
Gene, do you want to go?
I just got one question. I do believe you guys have a thing in common police court going on too, for the same.
In an abundance of caution, we filed an appeal here before the BZA and in Common Pleas Court. The city has taken the position that this is the appropriate forum for this to be first heard.
And if it's denied here, then it would go to common pleas.
Correct, but tonight is important because we have to build a record and we have to present evidence and we have to present witnesses, and that's another reason why Member Rodriguez or Gonzalez were not prepared to go forward this evening fully and finally to create that record. And affording us a modest continuance of 1 month would alleviate those concerns.
Still there?
No, I'm done.
You're done?
Right,
Okay.
yeah, for right now.
So Preston, question for you. So our requirements are to first-class mail notification. How do you know where to send those mails?
I use the Champaign County Auditor's website.
Okay, so whoever owns the parcel is who gets it?
Right.
Okay, so in this case, I mean, there's a number of parcels involved, what,
6.
yeah, 6 of them total. So did 6 letters go out?
I mean, a
So,
lot more than 6 went out because it's applicants and contiguous and anyone within 200.
okay, right. But as far as the owners of the property, so you're gonna look that up, they're gonna have an address in the Champaign County system.
Correct.
That says, here's the owner, here's where we are.
Right.
Which you would use as a mailing address.
Correct.
So is that, do we know, is that the office of Thor? Do we know where these would have gone?
I used the auditor's website for any vacant parcels. In this case, the ones that are being applied for listed both the owner and tax mailing address, and that's where the notices were sent.
Okay,
So we had Thor scour its records, its mailroom again this morning, and I'm not ascribing any bad motive to anyone in this room, but it has not been received, and we would not have learned of this but for me following up and asking for a hearing. And given the gravity of public interest in this, given the substantial investment my client's prepared to make in this city, and that it hangs in the balance here tonight, I think a 30-day continuance is the only, when these are routinely given for much lesser reasons.
yeah, so I just want to clarify kind of the whole situation here. So if the letters went out to the address listed on the site, or the Champaign County site, what would the city have to alert Voorhees? Do we have any requirement to alert Voorhees, being the attorneys for Thor?
The city's code, I think it believes, it says party of interest. I think we've always interpreted that to be property owners.
And surrounding
in the
property.
contiguous and within 200 feet. I can't speak to everything, the past practice of the zoning department, but that is my understanding of how it's historically been treated.
And cities routinely alert both clients with whom they've met, and the city has met with Thor's representatives, as well as their counsel. I would suggest to you this matter is of such importance. Why would the city want to go forward tonight and create another issue as it relates to our due process rights when we can all agree we'll come fully prepared on May 11th?
I guess the question in my mind is, if our zoning officer followed the ordinances of the city, mailed them where they're supposed to go, where are we in the wrong?
I
mean, that's,
I'll take Mr. Mitchell at his word that they were mailed to the owner, but they were mailed to an office in New York and have not been received. And everyone knows of the irregularities with U.S. mail since COVID. And I'm suggesting to you tonight, you all have taken an oath to uphold the city code and the laws of Ohio. The laws of Ohio afford due process to owners in quasi-judicial hearings like this. To go forward tonight on any matter, yet one of such huge interest and investment transgresses that right to due process. It is a modest request, but it will alleviate those concerns and issues later on appeal if need be.
Yeah, I guess the question, one of the questions in my mind is, okay, if we followed our process, okay, who registered what address with the Champaign County site?
I can't speak to that,
Right,
sir.
no, I didn't.
But I
it was
can
kind of
speak to
rhetorical.
how this creates another problem for the city in terms of due process rights and potential liability and needless litigation. You can take that part of it off the board tonight.
But how did we not afford due process rights if we followed our ordinances and requirements to alert? I mean, what
If you go
Thor's
forward,
doing on their end, we don't have any idea, right? We send the letter out, we have to assume it gets there,
and
right?
that's why I made you aware of this issue this morning in the motion for continuance. Due process is the right to be afforded a full and fair opportunity to be heard. We don't have that tonight. And just saying we followed our code doesn't alleviate that concern or that problem. I'm not ascribing bad motive to this board.
No.
Certainly, I'm just simply saying, as a matter of necessity, to take these concerns off the board so that it doesn't create other issues and a host of issues that cloud up this matter even further, and to satisfy our due process rights, which you all have taken an oath to uphold. A continuance serves that purpose.
So Preston, timing question. Do you recall when those letters would have gone out? I don't think you have to be exact.
A week ago from this past Friday.
A week ago from this, okay.
That sounds like the
So,
You said it didn't need to be exact.
okay, so
That is my exact
you're
date.
you're right, I know, I learned my lesson a second ago.
so that sounds like the 10th day, and I would reiterate the concern.
April 3rd, okay.
There is also a due process concern created by only 4 members being present tonight.
Why is that?
Because you're entitled to be heard by a board, and this board requires 4 votes for an affirmance of an appeal. The board is more fully constituted than that, and due process, again, affords a full and fair opportunity to
But
be
we
heard.
have a quorum of 4, right? So we could vote on this. We could vote to, yeah, we'll do a continuance, we'll give you time, that's great. You would be okay with that. But if the same board of 4 people said, no, we don't want to do that, you'll have a problem with that. So it's kind of, right, I mean, I understand.
I'm not saying you're transgressing your rules. I'm saying it creates a concern when the issue is of this much importance and significance,
Mhm.
both to the community and to my client.
Anything you want to add?
No, I think everything that Mr. Miller said about the law is right. That, you know, and again, I would say that not having a full board is oftentimes a reason that a continuance is asked and given or granted. But again, I think the quorum of the board is here and can hear the case if they so wish, whatever the board